technical issues on the attendee side, Spring Miller will be monitoring her email, spring.miller@vanderbilt.edu. If you need to let her know that something's not working on the attendee end, please feel free. And otherwise, I think we'll go ahead and get started. So I'm Sarah Mayu. I'm a professor at the law school at Vanderbilt University, and I'm here to moderate and ask some questions and get the conversation going. But mostly I'm here to learn from the panelists along with the attendees, and I'm very grateful that we have such a great lineup. So I'm going to quickly introduce each one of them, abbreviating what for each of them is a much longer list of achievements, just in the interest of getting us started. But we have today Tom Castelli, who's the legal director for the ACLU of Tennessee. And so he represents all Tennesseans in a variety of litigation enforcing the guarantees of the Bill of Rights. He's brought lawsuits challenging the use of solitary confinement in juvenile facilities, the lack of medical treatment for prisoners in state penitentiaries, and relevant to today, of course, has also challenged government policies interfering with people's free speech rights and right to protest. We also have Senator Brenda Gilmore, who's been a member of the Tennessee State Senate since 2019, has been serving Nashville before that for more than 20 years as a strong voice for North Nashville in the City Council, and also a member of the Tennessee General Assembly before joining the State Senate. Most recently, she's worked on a variety of issues, including opposing an English-only initiative and working to lower expungement fees to get criminal records cleared, and a variety of other issues during her time in public office. We have from our own faculty here at Vanderbilt, Professor G.S. Hans, who joined us 2 years ago to launch the Stanton Foundation First Amendment Clinic. And so he works with students at the law school on a variety of First Amendment legal and policy issues here in Tennessee. And he has also published widely in both journals and media on civil liberties, intellectual property, and been cited by the United States Supreme Court in dissent. And then finally, we have Justin Jones with us, an activist, graduate student, and community organizer in Nashville, who in the tradition of John Lewis and many others in Nashville's civil rights history, came to Fisk University in 2013, and inspired by the legacy of student-led movements for civil rights, became quickly involved in a variety of organizing campaigns and has continued here in Tennessee to be involved in a variety of campaigns, including what we're going to hear about today. And also in 2015, helped to file a lawsuit against Tennessee challenging its restrictive voter ID laws, among many other efforts he's been involved with. So a terrific panel that will give us a kind of panoramic view of different activist, legislative, and legal constitutional perspectives on this recent Tennessee legislation. So what I'm first going to do is I have a quick list of kind of introductory questions for each panelist to give us the lay of the land of what this law is, what it says, how it came about. To ask questions of one another or discuss, follow up on what each other have said. And then we do have a few audience questions that were pre-submitted that I will hope to get to at the end if they haven't been addressed in the earlier discussion. So we only have less than an hour. So with that, let's get started. So first, I was hoping we could start with Professor Hans to just give us a quick overview of what exactly is this statute. What does it say? It's been getting a lot of media attention, and the shorthand is that it's the new anti-protest law. But what actually does it say? What does it actually prohibit, et cetera?
Yes, thank you, Professor Mayu, and to Dean Miller and the Law School and Social Justice Program and the students who really brought this together. I'm going to be pretty brief because I will rather hear from the other panelists, but I think it's great to start with the text of the law. As a law professor, let's look at what the law actually says. I think I can get my screen to share with, I can't, but if you look on the Tennessee legislative website, the bill is, if you search SB 8005, you can pull up the text of the bill and you'll see that it's quite long. And I'm sure Senator Gilmore can talk more about the rapid process by which this bill was enacted. But I think the fact that it has so many different provisions means that perhaps some people are a little, find it hard to parse out what went down in this bill that was enacted into law last month. So I, upon rereading the bill and thinking about it, sort of put its goals into two main buckets. The first is a lot of increased penalties, fines, and levels of both felonies and misdemeanor crimes that the bill elevates. So we have misdemeanors versus felonies, and those are different classifications of criminal laws. Within misdemeanors, there are Class A, Class B, and same for felonies as well. And the class refers to the penalties or the jail time or what the repercussions are for violating that criminal law. The law, based on my reading, just wholesale for every criminal penalty that it takes up, for every criminal violation it takes up, it increases the penalties. It basically elevates, whether it's a financial penalty or it has to do with jail time, things like that. So it's one that sort of increases penalties for a range of criminal violations. The second part of the law that I think of has to do with how it regulates the act of camping. And my understanding is that part of the sort of baseline camping regulations that this law is building upon has to do with the Occupy protests that took place almost a decade ago now, which led the legislature to pass a law called the Equal Access to Public Property Act. This law basically makes some modifications to that, again, making the act of camping more restrictive, creating a notice requirement, things like that. And this is where I think many of us, including me, think it has specifically to do with the protests that have arisen since the murder of George Floyd over the summer, at the beginning of the summer, and how that has played out, worldwide, nationwide, and certainly here in Tennessee and in Nashville. And that's part of the reason I think that we have come to colloquially call this the anti-protest law. I think that's probably a good place to start. The only thing I will say, this has gotten a lot of attention, again, for all the wrong reasons. I wish, that we didn't have to have this panel here for obvious reasons. I think it sends a really bad message to everyone, in particular for those who are fighting for racial justice and social justice, which, we have so far to go in this country and certainly in this state. One thing that I often said when I was having conversations with reporters or with students or other interested parties is that we have seen in this country a long overdue move towards decriminalization around a number of different areas, whether it has to do with drug crimes, property crimes, reenfranchisement of people who have felony convictions. And this law, I believe, in its sort of single-handed focus on increasing criminal penalties, is exactly the wrong direction to be going in, not just for all the values that we hold in the Constitution related to protests and what we think should be criminalized, but also the trajectory of what we've seen in this country when it comes to criminalization. It's become a bipartisan issue in many ways to decrease criminalization, to decrease prison populations, to promote reenfranchisement of people with felony convictions. And this law just completely flies in the face of that, which I find particularly galling for my purposes. I think I'll stop there and look forward to more questions and discussion.
Okay, thank you. So, so just to recap a few bullet points, if you want to look this up, as Professor Hans mentioned, it's Senate Bill 8005, which was enacted in August of this year. And one of the key provisions as mentioned, is that it provides for felony punishment for camping on state property, which would include the grounds of the Tennessee State Capitol. And so I wanted to turn to Justin Jones to share with us a little bit of your experience this summer engaged in actions surrounding the Tennessee State Capitol that seem to have been the impetus for the legislature's concern with this issue. So if you could just describe for us a little bit the events of this summer, your involvement, and I know you testified against the bill, I believe, when it was being considered. So kind of what was your, how did you experience the legislative response to what you were engaged in this summer? And I think you're muted, so.
Thank you. Thank you so much for the invitation to share our truth, our story of what happened this summer, which begins on June 12th. It's when myself and a group of young people, went to the Capitol after the murder of George Floyd to say that we cannot have business as usual. And so we brought canopies, we brought food. We were led by indigenous activists here in Tennessee who gave us permission for this occupation, because we know that the language of occupation has a very racialized history of white supremacy, and so we wanted to do it in a respectful way. And so we set up kind of a people's plaza on June 12th outside the Capitol to say that we have two demands, and that is for the governor to come out and meet about the issues of racial justice and police violence in our community, and also for the removal of white supremacist symbols in our Capitol, like the statue of the KKK leader Nathan Bedford Forrest. And we said we would stay there. And that first night, it kind of, the troopers, they had about maybe over 100 troopers out there who I guess been on guard since the first protest in Nashville, who told us that we could stay as long as we did not set up camping tents. We said, we don't have camping tents, we have canopies and we have some tables with food, and that is it. So they said, okay. And so we did that. We stayed the night without issue. The guards, were out literally about 5 feet away from us, keeping watch throughout the night, but there was no issue. The next day, the guards came out and said that, we have to clean up the plaza. We have to power wash it. So you have to get off the plaza and then you can come back on the plaza. And instead, the complete opposite happened. That was when we saw the first escalation by Governor Bill Lee, where they told us to get off the plaza, brought out 200 troopers to form a line, and then put barricades around the steps of the Capitol. The first time that this has happened in my 7 years being at the Capitol protesting and testifying and being actively involved, and told us that the Capitol was now closed, that no one was allowed to be on the Capitol and on the Capitol grounds. And so that was the first escalation. In addition to stealing our property, all the things that we had, the food, the canopies, all the people's personal belongings, the troopers took away and said that we would have to get them from their headquarters to retrieve our belongings, which we know is unconstitutional, this unreasonable seizure, this unconstitutional seizure of our property without a property receipt, without any acknowledgement of why our property was being stolen. So that's when we saw this escalation, and we from there just continued to escalate exponentially with more troopers coming to raid people's property. Again, we were there for 62 days. In that first week, we probably saw 4 raids where they would come in the middle of the night or the middle of the day or early in the morning and just steal people's belongings. And at that time, there was no arrest yet. It was just all harassment. It was targeting, with video cameras walking up to people, and it was stealing people's belongings. And then about beginning on the 4th of July, a couple weeks before the 4th of July is when we start seeing mass arrests as a form of escalation. This summer, there was over 200 arrests at the Capitol, the most that have happened in Nashville's history since the sit-ins in the 1960s. Many historians have told us. And so we start seeing this mass arrest. We start seeing escalations of them for the first time arresting people under this anti-camping statute, quote unquote, the Equal Access Law. And that's when we start trying to reach out to lawyers saying that we see what is happening. We see this escalation. We see the young people not only getting arrested, but being brutalized. A lot of the young people out there, one of my dear friends from the Vandy school, Terry, got a black eye, had her arm broke when she was, pushed down the stairs. We had some of our friends who are homeless who were also assaulted, who had stayed out there with us. And so we start pleading with both lawyers and lawmakers to say that this is really escalating and someone will get hurt if we do not have intervention. And so that's kind of what we saw with the escalation this summer. We know that the governor responded by calling that special meeting of the commission to remove the statue, thinking that would get rid of us, which it did not. We saw then the state Capitol Commission saying that, now you cannot stay here or you'll be they put papers up saying that you're in violation of the law if you stay here. But we still chose to remain to stay because we knew that law we were not breaking that law because how camping was defined under that statute was very limited. I mean, we were not, under the definition of that law. And so that's why I think with this new law, we see this expanded definition of camping that is much more expanded. We see this, we see increased penalties for things like chalk. This is something that was not discussed. But we had an elementary school teacher who was charged with a felony for chalking, writing the names of Black people killed by police, and was charged with a felony. And we see that in the law, making that a felony moving forward. We see also another tactic in this law, which is called those mandatory holds, where if you are arrested under camping or chalking, you have to stay in the jail for a minimum of 12 hours before a night court commissioner